Come out the jetty, come all the way up.
All ready?
Oh, how far? Fishing tour.
Of course. All right, I'm gonna go ahead and call the meeting to order. We've already confirmed our quorum. I need to proceed. The only item of business tonight is we're just gonna go over the proposed bylaw amendments. We're gonna consider this, discuss it, and then we're gonna vote on it. So, I will go ahead and open the floor up for discussion. I think everybody has either read this or hopefully got a copy of it up front. At this point, I'll go ahead and open the floor up. Basically, I'll call on anybody that wants to have the floor. You can talk, and then if you're done, I'll pass it off to somebody else. We can keep it to one person at a time, just so everybody has the ability to ask their questions and we can answer. So I will open the floor up at this point. Anybody? No discussion at all? No questions? Okay. All right, Leanne.
I'm Leanne Black. I just had some, after I reviewed it, I feel like some of the points are good, but some of them I have concerns with how it would ultimately affect the neighborhood. Particularly the change to Article 4, Section 5, action taken without a meeting. I don't know, is that one? I think it was actually the section above that, the note that I had made to myself. My concern was that with changing the percentage of people that would be able to make a decision, it's the part that says add the following, and that if a quorum is present or represented. Essentially what it boils down to is it allows a potential minimum of 33 people in the neighborhood to make a decision on behalf of the other 95% of the neighborhood. And for important decisions, it just seemed to me that that was not really a reasonable percentage to be making decisions on behalf of the entire neighborhood. I think there's a reason that you require a larger percentage for certain types of actions, and so I would ask people to consider that. The other section that I had concerns about were, and I don't think there's page numbers on this, but back, is there a page number? Not on the copy I have. In Article 16, it was asking to add comments that said that each and every member of the association shall have unlimited access to attend and observe any and all meetings, including board meetings. No executive or closed sessions of the board are permitted, and that was that presents a major concern to me as far as if the board has to be deciding some things that entail reviewing privacy issues between members of the association or negotiation terms with bids that we're making prior to the bids being decided upon. I think tying the hands of the board to not allow executive session is of major concern. To me at least.
Which section was that?
That was article, it was the next to the last page before the signatures, Article 16, Section 1, talking about member access to records. And then at the very bottom, it says add the following, and I'm hoping that my version
So
is...
both of those are concerns of yours, the entire paragraph and below it?
No, the comment that I made of concern is of concern. The fact that there is no executive or closed session of the board permitted, period. I mean, I think that that's a concern to me to make a sweeping statement like that to completely eliminate that ability of the board. That's a pretty reasonable standard expectation of boards.
So those are two different things right there.
Yeah, there's section 1 and section 2, both under the same article.
Okay, so it's section 2, I guess.
Okay, so just section 2, not section 1, you don't have a problem with.
I do, but I'm not going to go into all the details of every one that I have, because I have a lot of concerns with a lot of these, but for purposes of discussion, I just wanted to bring those two major concerns that I have.
Okay.
You know, reply to that, you talk about the 33 people to change. I mean, there's 435 of us in the homeowner association. Look at us tonight. There's probably only 33 of us here. So, you know,
There's proxies.
we're never gonna get everybody to come, and you're not gonna get but this group here.
Agreed,
So,
there's
yeah.
proxies in place for this meeting, so it's actually more than 33 people actually affecting the outcome of this meeting.
Yeah, if you do the math for
Doesn't
tonight,
it say in
hang on one
Article
second,
4?
ma'am. One second. If you do the math for tonight, we've got, what, maybe 25 people here, but 130 have expressed an interest in their vote being heard for the outcome of tonight. So
Right.
really, we've got
Right.
almost a quarter of the neighborhood roughly, which is what the requirement was before.
Right.
Well, you were first, I'm sorry.
But it also states that when, because I was underlining that when you were talking, if a quorum is not present or represented on proxy, so you could always have that as an option for something that's a major deal, as you put it, or, you know, that they can vote on proxy.
But the way, that if you change the bylaws to word it, the way that this is worded, it's eliminating the need for it. So it's not saying that sometimes you could need it. It's saying that it would be allowable.
I thought the quorum said, it says the quorum is 65 people.
Correct.
Right? Where were you talking about? See, it says, I don't see it changing to 5%.
I think it's not in that section. The 5% is on the very first page where it says special meetings can be called by 5%.
Yeah, let's just call it a special meeting, it's not
That's called a
changing.
special meeting, yeah.
Right. But so then once the people are there at the meeting, the number of people required to pass that through is quite small.
Right.
65 or 10%.
Right. And so a special
And
meeting,
then it's a majority of that.
So it's the
33.
same as it is currently.
the difference is the meeting would happen. So essentially with this, 30 people could call a special meeting every week of the year. And then that one person, like in this situation, we've got 130 proxies. So you could essentially get your street every week. And then with those proxies that you yourself have collected, dictate the entire outcome of the neighborhood.
Yeah, but the 5% isn't that a state law? It is a state law. It's
Yeah.
we call a special meeting 5% of the membership.
Unless you have more restrictive covenants, which we do currently, which is why we don't have special
State
meetings.
law.
It's more restrictive, that means more protected.
But then we can comply with state law.
Sure.
So we're just making it match state law.
Right. What that's doing though
Which
is,
is minimized.
yeah, minimizing the requirement. So the scenario that I would envision happening, just theoretically, is one person could literally change the entire community single-handedly with that.
What do you see, what's your percentage number, call special meeting, what would you?
What it currently is. I don't see a need to change it.
Yeah, I mean, we've been able to call this one with no issue.
What is it currently?
It's 25%, quarter, so 100.
Of the total association,
Mhm.
does that include proxies if they?
It does. Which to me seems reasonable. I mean, that's not even half. It's just showing an interest by a diverse group of people.
Well, it appears that there's a majority of people in the association that don't really care to get involved about it, so the ones who do care may not be the majority, and may not be the percentage that you guys are requesting. So if there's a smaller amount of people who truly do care in this association, then I would go with what's on this.
I think that's a valid point. I think the only issue is if somebody has a particular agenda and the other people maybe are not inclined to participate as frequently, anybody can steer it.
They should come to the meetings.
Yep. It's a
I'm
fair
sorry,
point.
that's what an association does, right?
Yep, fair point.
They should attend.
Did you have a?
Well, I was going to point out what Artemi said, that it matches the state law, the 5%. And the mere fact of the matter is, we already hold enough proxies for a quarter. If the people didn't want that change, then they wouldn't have given us the proxies.
Yeah, that's true. The only variable, just in my opinion, is when, I mean, I've been on the board for a few years. Generally, the meetings don't have this sort of proxy attendance, which means that an individual is making the presentation and soliciting that proxy.
And people are signing it, so.
Correct. The concern for me is that I don't know what information is being presented to the person who is signing the proxy. They could be being told hypothetically, anything. So when you've got the ability to just have one person walk around the neighborhood and say, here's what's gonna happen, here's what this really means, and you should vote this way, the person's not getting to see this forum, which is call and answer, response.
Which is their choice, though.
Yes,
Ultimately, that's true.
that's your choice.
It's true, but if someone were to say, I am on the board, I'm sharing with you a factual account of what's going down, that person might be inclined to believe that. It's just a personal concern. That may not always be the case, but
Isn't that the problem with all proxies in the first place?
Yeah.
Is that
I agree.
really proxy voting is not the best.
It's the worst, in my opinion. It should be used as a, I'm out of town, I'm crippled, I can't make it. It shouldn't be the way that we steer meetings, because.
You'd never make any progress then.
What's that?
You'd never get enough proxies. You wouldn't make it. If you put those restrictions on proxies, you never get any business accomplished.
We're not talking about making everything.
Yeah.
No, I'm saying I'm following up on what he just said.
But what we would have is decisions made in the form in which they are being discussed. So we know everybody's getting the most accurate information.
Well, I think you could draw a line in that sand anywhere. It is what it is. It's written. You got the proxies. We take the vote and see where it ends up.
I guess if it was important to the ones that weren't here, they would be here, and they would have given proxies as well to maybe board members to vote.
Or they might not be aware that there's so many proxies being cast.
But didn't you send a notice to some of your employees?
Everybody.
Yep, you guys,
That's all I knew.
So I guess
That's what I got lit.
you know, I
Got a
conversation,
conversation.
I heard you
Everybody
guys
got a
saying, but obviously all these others don't care as much as we do. So, I mean, we're smart, intelligent people, so we're making this decision, we've got enough proxies.
Yeah, no, you've got enough to do it.
My
Just-
only point is that when you minimize the number that is required to make a decision, that would minimize even the number that had to agree to hold this meeting to begin with. And so it just minimizes the threshold for doing anything, which allows a very small, very, very small group of neighbors to make decisions on behalf of all of the rest of the neighbors, whether they're interested
Kind of like
or
a
not.
board.
But that's,
Excuse me?
that's what you guys do sometimes, you
Right.
make decisions without.
Well, we operate as a board, we operate under the duties that we're assigned. That's not the duties of the general
I
membership,
think
that's a different
unfortunately,
thing.
I've only been here a couple of years into the history of not this particular board, but this whole Chatham plantation. I think the matter of trust is just not fair.
Agreed.
So I think with the few that we have on the board versus the ones who care and who are voting on this and they're here tonight, you know, I'm still okay with it.
I'm just throwing things out for
I
discussion.
appreciate it.
Unless anybody else has another comment, I have another point that's not related to those.
Well, I wanted to confirm, the part where it says the members could have access to any information at any time, you didn't have any issue with that one, right?
I think it was the second part of that.
I'm going to touch on that one.
Is that Article 16? I'm sorry.
Yeah.
Part one.
Okay, so it was Section 2 that I was commenting on, which is at the bottom of that page.
My bad.
And it's the very last statement of
Okay.
that, the executive session issue. I had another concern, actually, as I'm looking through this. I'm sorry, I'm just arriving from work and switching gears here. So, on the page that has, which is page, the third page, Article 5, Section 2, election. It's asking to delete that election to the Board of Directors would be by secret written ballot. And I have concerns about that too. And we've had some contentious meetings in the past 2 years, such that I feel like certain people might be a bit intimidated to make a public vote if they were in disagreement with some of the contention that was happening. If you eliminate the secret written ballot that we've operated under.
And the secret ballot doesn't create anonymity, it just doesn't let everybody else see what's
See what
happening.
you're voting.
They're still recorded.
But who looks at them to record them now?
Currently, we would have our community management group go through, and then those records are retained if there was ever a question as to validity. I don't think there's ever been a situation where it was down to the
Community
wire.
management, I don't know, what will be or not.
Experience
Depends on who
enough.
you're asking.
Yeah, to me personally, I've not had any sort of concern with that. the secret thing, I kind of agree with you. It's like, just like voting for any public office. It's strange to remove the ability of someone to vote their conscience in private. I'm not really sure what the purpose of that is.
Well, when we vote for the President of the United States, even though it appears to be private, it really isn't. You still have to say your name and social security number and stuff.
But they don't know what your vote is.
Yeah, it's identical to the way it is
It's
now,
the same.
which is it's a secret ballot.
It's just like here, you have to sign in, we know you're here, but we don't know your vote if it's a secret written ballot.
Yeah, we
As
would-
opposed to, you know, a very vocal, intimidating group affecting others' ability to vote what they're really thinking potentially.
I want to respond to your executive session. I don't agree with that. This is not a government. This is a nonprofit organization. I think everything ought to be transparent. There's no reason to not disclose anything. And I'm basing this on the basis of how y'all conducted executive sessions, which is totally been inappropriate if I did agree with it. I mean, you make major decisions that none of us have any input in. And I don't like that. You just missed a civil suit without our input.
Well, in response to your comments, whether or not it would have been done in executive session would still not have required community input. When the board is conducting business, it's the board's business. And
No, it's
there are
not.
some
No,
things.
No.
This is not the government. This is a nonprofit organization.
You work for us.
We don't even need a homeowners association. We got one that we have to
It's our
deal
money.
with. But, you know, you are supposed to be working for us.
That's right.
Yeah.
We do.
No,
Well,
no.
in secret? Oh, come on.
Come on.
And if I might, hang on one second, just to respond to your comment, I'm going to give you just one of dozens of scenarios where executive session is useful. Say that you, Steve, hadn't paid your dues for 10 years and your home was in foreclosure. Here's how that would play out. We would have to decide what to do with your particular account. The whole community is sitting here and we go, okay, whole community, what we're going to do now is talk about Steve's personal finances in front of the entire community to be recorded, viewed, videotaped, and publicized.
Well,
That's what I was going to
have
do.
you ever looked in the public notice in the paper and seen delinquent taxes where if you don't pay boat taxes
It was in
and
there,
you don't
it
pay
was
your
in
home
there the other
taxes,
day.
it's public.
Pages.
I could read
All
it.
of it's
Well, I'm
public
just saying,
documents.
that's an
What's the
example.
But
difference?
this is an
Right.
example of how it's published. So, I mean, if the government does it, why would you want to
You
keep it?
just said we aren't the government, right? This is a
Well, I
completely
know.
different situation.
Well, no, I think it excluded that part.
I don't
No,
believe it
does
does.
not.
No, it doesn't.
It says without exception.
Okay, I have been here for about 5 years, and I don't know a lot about the South Carolina law, but I do know about the Texas law, and I've served on many, many boards. In Texas, if you go into, if a board goes into an executive session, you cannot take notes. You cannot. That would be something that would be interesting, because it is not to be accessible because the board, otherwise you wouldn't go into executive session. Because the secretary is supposed to be taking notes, but when you go into executive session, it's all down, recordings are off.
Right.
If you're not an elected official, you have to leave the room. I'd be interested to see what it is in the state, if there are any, I don't know if there's any lawyers, if there's any. That's
right up there.
Ask him, you right there?
I don't know what it is.
Take the names,
That's
what
part of the
they-
reason for executive session, so that there's not information to leak out.
Correct.
And the other part of that
Usually
is
what we
if
would
you
do is, hang on one second.
Okay.
Usually what we would do is if we had the executive session, we would discuss it, then we would come in and vote.
Yeah, and then you have to come out and
Say
any
what you
action you take, you have to announce what action you took.
And
So
you
if
have
you put my
not.
house in foreclosure and you agreed to do it, you have to come out and announce what action you took against me.
Yeah,
So
the
it
action.
becomes
But not with
Discussion.
names. It
Oh.
would be,
Where
But
you haven't
where
been
does it say
doing
that?
You have not been disclosing that information when you come out of executive session.
But we always, yeah,
we
there's
disclose
an action.
that action, but we usually vote outside, I mean.
And I've even been told before by Aaron, I will not tell you what I did, it'll be in the minutes.
Right, that's correct. We
Which is
don't discuss the
unacceptable
content.
because you didn't say what you did when you came out of executive session.
Right.
Okay, so at least you know that this one was avoided, but the note you made about the state. You're a lawyer for the board? Okay. Nice to meet you. So all these things these guys are passing back and forth, do you know these, can you confirm them or something?
Well, I'll make an observation on the executive session. The example that Aaron brought up, and I don't know this gentleman, Steve, did I?
Steve Taylor.
Mr. Taylor. The hypothetical whereby the association has sued you if you haven't paid your dues. Your lawyer has made a settlement proposal to the association. And as part of that is explained that you lost your dog, or your wife's been sick, or you lost your job, or whatever. And in trying to pitch your settlement position, your lawyer has given information about you to the association's lawyer to give the association reasons to compromise. And so there are hypothetical details about your personal life that don't need to be made the business of every member of the association. That's one example. Another example is if the association is in a business negotiation with some vendor, and the vendor is offered to do something at a certain price or on certain terms. The association wants to make a counter proposal. If they have to discuss the counter proposal and the pros and the cons of the counter proposal in open session, they've completely lost their ability to negotiate with the vendor. The vendor knows what their position is. And so eliminating executive session is just an awkward, bad idea. And a future board will be sorry that this amendment got passed in that respect. That's all.
Well, I respect your opinion, but in my opinion, we don't even need an HOA. There are plenty of neighborhoods that operate without them. I know we're not here. I know we're not here for that today, but I think that this board has been they have not been transparent. That's why we're sitting here today. We wouldn't even be having this meeting if we'd have got the information back last year when we came, a core group of us came. Total trust is gone. Total trust in this board is gone.
Yes.
Our bylaws state that that information is to be made available to us, and when you're discussing delinquencies, do we not have account numbers? Why do you have to use a name? I mean, you're acting like that's a big deal. That's very easy to get around, just use an account number.
If you're sitting in a room talking with other board members, the discussion wouldn't be account 02006 is delinquent. You'd say Steve.
Or you'd say homeowner A, and that would take care of it.
That's just one example. I mean,
Yeah.
any number, so then you would say, all right, homeowner A at 136 Lindbergh Court.
You have to say the address even. Well,
You have to reference the address.
well, that's public.
Homeowner A, and the fact of the lawsuit is public knowledge.
Yeah, I mean,
So any member who was interested in finding out who is the association sued for non-payment could easily do that. And the board's ability to confidentially discuss in a confidential way the merits of that case would be jeopardized by eliminating the executive session. That's all I'm saying.
yeah, and I mean, I can see the situation where somebody who's not in this room tonight perhaps becomes the subject of discussion during a meeting. And in Katie's example, something comes out that maybe is particularly harmful to them personally, and it becomes public knowledge. I don't know what the implications could be, but I mean, there could be some sort of suit that could be filed by that individual. I mean, even though the covenants are going to be what they are, it seems like we're creating a very big potential issue for a board. I mean, I would be afraid to operate on this board with that. You know,
So you'll step down once it's passed?
I'm just saying, I would be afraid to be on that board because of the personal liability. I feel like I would be open to it. That's just my 2 cents on it. Yes, ma'am.
I feel like you're just wanting to make excuses for what you've been doing these past couple of years. When we've come and tried to get answers to questions, we've tried to get answers about contracts, and it's been like a secret ballot. It's something we know we can't know. That is not appropriate. I'm a certified public purchasing agent, and as such, I know what the rules and regulations are, and I know that you don't have to have these secret negotiations with just one contractor if it's done right. And it should be done right. It should be fair competition for everyone. And that's how it has been here in the past. Because I know when my husband was president, we had fair competition. We didn't have all these secret ballots and secret meetings. Everything was transparent, and that's how it should be. And there's no reason it should not be. Because then you're being unfair if you take something and you're giving one person an opportunity you didn't give someone else. You should go back and say, okay, I made a mistake on my specifications, and you need to revise them and put it back out to everybody. You need to be fair to everyone. And then you're getting a fair price. You're not getting an unfair price. And I can say that because I've done billions of dollars in contracts, and I know what you're supposed to do, and I know what we're not doing, or you wouldn't have it all so secret that you wouldn't let anybody look at it.
Okay, to be clear, to my knowledge, we've never held a secret meeting, firstly. Secondly, the process by which we select vendors, ever since I've been on the board, has been done with an open RFP. We've put it out, solicited multiple requests, and then chosen the most cost-effective option. So the scenario that you just painted, to my knowledge, does not exist.
And you've released all the contracts, including the CMG contract for review, to anybody sitting in this room.
That, as we're supposed to do.
Yeah, the contract is available.
I know that.
How many of us have asked for it and been refused?
If I remember correctly, that my first meeting was last fall, and you guys passed the budget in a secret meeting.
Yeah, we've never had a secret meeting.
Well, we
Secondly
weren't
is,
allowed to attend that. It was the board of directors voted down budget, and you told us that we didn't have any, I don't know the right word. Someone help me out?
Input.
Voting rights or nothing to decide on how our money was spent.
the budget is one of the specific tasks that is prescribed to the board. That is our job to vote on the communities. The board is elected by the community, and then one of the tasks that they perform,
But the way you spend our money is our business.
it is your business, yes.
And if
The
we
budget is
disagree
not
with
how we
your
spend
budget,
it.
but if your budget is our money.
The budget is not how we spend money. It's what we allocate at the beginning of the year, and then out of that,
And if we
we spend money.
disagree with you wanting to pay maybe, I don't know your name, nothing personal, but this gentleman $60,000 a year to do something, we don't have a right to say,
The reason for a board of directors is so that we don't have to have a vote for every decision that is done. It would, no business would ever be done. You couldn't call a vote. The number of decisions that we make on a monthly basis, it would be impossible to call a neighborhood vote on every single
I
decision.
think you
That's why
guys are a lot more trying.
Is it not true that the board,
I think it's good that we have the board and like something to be transparent, and if the trust is lost, you just can't gain it back by saying it's board's right. So that's why we're voting the way we're voting. Unfortunately, that's where we're trying to, in the majority of the association, if they're not here, they don't care.
So-
is it not true that previous two persons on this board, on the board, maybe not with y'all, knew what the contracts were, and they underbidded the contractor and took the contract and got off the board because they knew the board?
I couldn't comment on a board that I wasn't a member of. I don't know.
Well, I think you might have been on that board for one of them,
What example are you referring to? I'm not-
you know. I mean, they see the contractors, they know exactly what the contract says, and he undermined it, the guy that had the contract.
Since I've been on the board, we've had a continuous, the only vendor contract we have is Jerry Ray, and that was a place.
Exactly what I'm talking about. Thank you. I didn't want to mention his name.
He's been serving the community far in excess of my tenure.
Yeah, but he was on the board and he saw what the bid was and he undermined that guy and got the contract. Now, I know that for a fact, and Mr. Sullivan can
No,
verify.
he did not see it.
He didn't see it?
Quit
Yeah, he quit because he knew what the contract was.
before we looked at the contract.
Okay.
Anyways, specific questions to the amendments, if we could,
I
for
don't have
discussion.
any-
I'd like to comment. I'm gonna yield my seat to you for a moment, so that I can talk freely as a homeowner. There's just 2 points that I want to mention that concern me. Again, if I was on the board, this would frighten me. On the second page, you get into the second paragraph where it says, add the following. I'll just read it first. Any director can be removed from the board with or without cause by the vote of members equal to the amount of votes necessary to elect the director at an annual meeting of minutes. Yeah, sorry, members. If a quorum is present or represented by proxy, the rule requires a majority vote in favor of removal of the members present. So if you couple that with the first one that says special meetings can be called at any time by 5% of the community, what I perceive as a risk is that you could have your entire board turn over every 90 days. And that may be okay right now. Perhaps people want to change up who's on the board, I understand that. My fear would be going forward, how that would affect the community, having a board of perpetually zero tenure that can be replaced at a whim at any time. And I'm not trying to protect my seat. If I'm here or not here at the end of the year, irrelevant to that. Going forward as a community, I think this opens you up to a tremendous lack of experience.
So if you vote a board in, you know what it is?
I'm speaking right now, if you would.
That also matches state law. That is a match of the state law.
Rebecca, I did not say that I think this is inconsistent with state law. I have said that I'm fearful for the community having a board of novices forever. They can just keep replacing themselves. Oh, I don't like him. I'm going to get everybody on my street to call a special meeting. Let's do a new board. Do it every 3 months. And I'll tell you, I know it seems maybe simple from where you're sitting. I know some of you have been on the board. There is no simple decision. We try to make the best ones that we can. So if it's not us, at least it should be someone that has that same mindset. But if you have someone that's brand new, 3 or 4 times a year, how do you think they're ever going to figure this out? I mean, you have to know the relationships with the vendors. You have to know the community. You have to know what's required. You have to know that you have the time to commit to this. I am fearful that you will end up with a board that does not know what they're doing. That's just concern number 1. I have one more concern, and then I'll come right to you.
No problem. No, that's
No, that's right. I'm not in charge. On the second to last page, Article 16 had the following member access to records. So this says, except as expressly prohibited by law, each and every member of the association shall have unlimited access to any and all records of the association without exception. That is, for lack of a better word, asinine. Because what that means is anyone can read anything. Records is defined as broadly as humanly possible. So does that mean that we can read emails between board members? Yes.
Yes.
Does it mean we can read emails between a homeowner and a board member talking about a personal issue? Yes. And can that person then publicize it? Sure they can. So now, I mean, that's like if you're a doctor, or if you're a tax attorney, or your regular attorney. Everything that you talk to them is now just fair game. And I think everybody in this room knows that there are people that will share this information globally with no regard to who it impacts. So just ask yourself, if someday you were in a situation where you had a personal problem that you didn't want anybody to know, with this in place, every single person on earth is legally allowed to now know. You have zero privacy. I agree with sharing the information, but there needs to be a line. And I mean, under this, there is no personal privacy for any of you. So just be prepared for that. If you vote this through, your personal life is out there for everyone to read, which, in my experience over the last 2 years, includes newspaper, television media, Facebook, anonymous mailings to the community. So if you're cool with that, and you vote this in, just know, someday if it's you, all your privacy is gone. Those are my 2 big concerns, and I mean really big concerns. And I am more than open to making some changes. I don't think amendments are a bad idea. These are really old bylaws. But God, I mean, if you really read these and think about the implications, and this is forever until they're changed again. This isn't just to kick us off the board or something like that. This is forever.
Not forever.
It is.
Yes. So on the one where it says you'd be switching over board members every 90 days, you know, in all my jobs of working, I have a 90-day period of where I can prove myself. And if someone wants to be a board member and they qualify for a board member, then they do a good job. I don't think they'll be switching around very much. There's a 90-day period in most places. Company can get rid of you after 30 if you don't do a good job. So why can't the association get rid of a board member if they don't do a good job?
Are those positions you're referencing generally leadership roles at the top of the organization?
Anything.
No, that's not true.
I
If you
don't
hire a
think-
CEO, they do not give them a 90-day
Well,
trial period and then flip them.
But you guys aren't CEOs, you work for us, so.
But we're the board of directors elected by you.
I
So if
understand,
you
but-
have somebody who is supposed to be tasked with steering the neighborhood, and they don't even have time to get up to speed,
We
how on
get that,
earth are
but
they
you know, I
going to do
think,
it?
I still go back to, you know, if, and I hate that, I don't wanna sound demeaning or anything, but you do work for us, it's our money. We don't even pay you, I don't even know why you want people, members, I don't want people. But,
It's not until one year.
but the whole idea here is you do work for us though, so since you've chosen to be on the board, which is admirable, you still work for us. So, yeah, I wanna say, hey, you're not doing a good job, and you're paying my money out, you're doing things that I don't like with my money, which, there's a lot of things you were doing that I didn't think it was took, but, you know, let other people take care of that. But the other part of it is, so the 90 day, that one I'm not, but, as far as the association records, isn't it limited to association records? It's not asking, it's not saying personal information.
It says without
It just says
exception,
records.
and it says records.
So
And if you're, when you're reading a contract and you have a key word like that, it says something records, and it's not further defined or clarified, it's open to any interpretation by anyone on earth. So whoever has the best attorney is who's going to win that. Or if no one has any attorneys, it says any and all records. So anything that has to do with the business of the community is fair game, which I interpret as everything.
Well, honestly and sincerely, you know, it doesn't matter what any contract says, if you have a much better attorney, you're going to win anyway.
Right, but why start with the crap one?
You make it a little harder for them.
Your email example.
Hang on a second.
Rebecca's hands been up.
Yeah, I just wanted to state that our covenants already say that we are entitled to all those records, and, you know, all these other associations that are following state laws, you don't hear them complaining about boards flipping over in 90 days.
Our
It just doesn't
covenants-
happen as a general rule.
Our covenants do not state it is open to any and all community records without exception. It's records that are relevant to the business of the community,
That's not what our covenants say. Go ahead and
they
read.
say.
I'd have to break them out, but that's not what it says. It says, as a member, you're entitled to the records during business hours, and you can pay for copies.
Yeah, and that is records relevant to doing business.
But it doesn't say that.
It doesn't state that.
Yeah, it does. It defines the records.
No, it doesn't.
ours.
And that's state law.
And it's also in the state law, yes.
I might make a
I
comment.
have two
Oh,
questions.
excuse us.
The question about records that Aaron makes, my concern reading this as a lawyer, and I understand that these bylaw amendments were written to address specific criticisms that a number of people have of specific actions and non-actions by the existing board. I understand that. The bylaw amendments do not appear to have been thought through in the sense of how are they going to apply 2 years from now in another board, another set of circumstances. The term here, records, is not defined. Under state law, any member of the association has the right to access on reasonable notice specifically defined records for that, and they have to define the purpose for which the records are being sought, and the purpose has to be related in good faith to the business of the organization. This doesn't say any of that, and this would broaden the access to records way beyond anything that is ever contemplated under the Nonprofit Corporation Act. That may be a good thing, it may be a bad thing, but I suggest to you that if you read this from a layperson's perspective, records of the association would mean any piece of paper or any email or any note, any post-it, anything that is in the offices of the association or in the offices of the property management company. And if you want to have everybody have the unlimited right to go into the office at any time and demand to see everything on the premises, then by all means vote for this amendment. But I think that you will find in the long run that that will have been a mistake. So that's my 2 cents on that particular.
I respectfully disagree with you.
Steve,
I know you do.
you haven't been recognized. This lady here.
So when you come president,
How many
Aaron appointed her.
He turned it over.
He
because
turned it over to you?
Yeah, he did.
I'm
He
waiting.
turned it over to me because he brought up an issue as a homeowner, and that, therefore, I'm serving in his role for now.
Under parliamentary procedure, if the chair wishes to address the merits of a question, he's supposed to relinquish the chair to someone else.
Why not to the vice president, though?
Because he chose to relinquish it to me.
That's his prerogative.
She's sitting next to me is the answer. Sorry, Rick. No.
First of all, how many board members are there?
There are currently 9 elected board members.
And every one of them have been elected by the community to serve on the board?
I was appointed to replace someone who had been elected and resigned.
Okay, and I'm sure in the bylaws that states that that's the
Yes.
procedure.
Yes.
Okay. I understand your concern with this Article 16. I think the first sentence where it says, "on all records of the association without exception." If I'm reading you right, it's the without exception, and after listening to whatever this gentleman is here. But I don't see a problem with what's listed as bank statements, financial reports, contracts, meeting minutes, resolutions, audits, and other company things. I don't know,
Right.
you're adding this to this Article 16 in the bylaws. So personally, as a homeowner that pays dues, I don't have a problem with that. But I do understand where you're coming from without exception. I don't need a posted note.
Yeah, it's just that first
You
line.
might not, but someone else.
Well,
The second sentence,
I
if
mean,
I may.
I'm hoping that what I'm seeing this role is because they want to have access to the financial, the budget, and all this other stuff.
Yeah, may I respond to you?
I'm sorry?
Can I respond to you?
Yes, yes.
So, yeah, you're in sync with me on that. It's the first part that says without exception. That is a very scary legal phrase when we're talking about personal records. The whole rest of that paragraph is fine. All that stuff should be accessible. Boards.
And are we here this evening to discuss this and agree to, I mean, I thought the purpose of the meeting is if we could have just taken it as it is, we would have just checked the paper and walked out.
Well, that was the purpose of having this discussion was, I know I wanted to raise a few points just to everybody. I mean, the outcome's going to be what it is, but I want to be on record as letting you all know from where I sit, what I see as a risky change
Okay,
to our
so
documents.
is this, at this meeting, is it appropriate to amend the amendment? I don't know.
Unfortunately, the way that the person who
It's all or
submitted
nothing.
it was to accept it in its entirety. What we could do, which I think would be wise, if people are of the same mind that I am, most of this is fine. There's a couple lines that just make me cringe from a legal standpoint. And once this is voted through, it's in. And I'm gonna tell you, I don't wanna be any part of that board that has to comply with this stuff, because I can see what's gonna happen, and I'm not gonna be a victim of it. So, that being said, a proposal that I would have is, if there's enough people that can at least hear what I'm saying, hear what Leanne's saying, what anybody else is saying, and think, most of this is good, might we try to approve them one by one? Or maybe have a meeting where we can discuss them openly, or give some feedback? This was written by one person, or a small handful of people, and then distributed for approval. I think it would be wise to solicit some more input, since the whole soapbox of this organization is transparency. Why would you write amendments and then cram them down people's throats? Why wouldn't you solicit the input first, craft them together, and then vote on them one by one? This is not like when they'll do something in Congress where they'll have a big thing and at the end they'll go, that gets voted through. When they slip that little rocker in, that's on record now. And that's what is happening here is holistically, there's some good changes and updates. But there's a few key phrases that I think are critical failures of the community going forward. And I would just ask that people think about maybe could we do these one by one, have some more discussion, but to vote this thing through as is, I think bad idea. But I'm more than willing to accept some changes. I agree. If anybody wants to respond back to me, I'll keep leaving it to Leanne, but if not, I'm going to
Is
go back.
it in response to him?
Yes, I disagree with everything you said. First of all, I worked for a government career. They could confiscate my computer, they could look at my emails didn't belong to me. People got fired because of jokes and everything else they have. They could look at my email anytime, I wasn't ashamed of anything. Everything should be transparent. Anything that goes in a file of the government, whether it's a Post-it note or anything you do, if it goes in that file, it's subject to the Freedom of Information Act. It's there for people to review. You got 15 days to respond. I know you don't have to comply with all that, but I'm saying this nonprofit organization needs to be transparent. If you have private emails, that's fine between you, but if it's board activity, you should be using an email that belongs to this association. So it should be transparent. Everything you do should be transparent. There should be no secrets.
But I
You
have-
work for us. Thank you.
And
The
just
only
to,
response I have to that,
if I can respond to Steve real quick,
You have to, you respond here.
I'm confused because your earlier comment opened with, you aren't the government, but you continuously are comparing us to the highly stringent restrictions of your government work. We
Listen.
aren't the government.
Are you afraid to follow the state law? Are you saying the individuals up there? I mean, Rebecca, we carefully looked at that. Artemi was involved in this. We're following the state law, so what's the problem? I mean, the state thinks it's fine.
I think I've been pretty clear, and